Hello, and welcome to Georgia's Association of Black Women's Attorneys program, Legally Speaking. I'm Kathy Carter, and I'll be your host for today's program. The Georgia Association of Black Women's Attorneys is a state-based organization, better known as GABWA. GABWA is interested in rendering community services and providing educational information. The program you are viewing is a production of GABWA. We'll be discussing on today's program the Probation Department of Fulton County. We have with us three very distinguished guests who have received much honor from the community and from their colleagues. At this time, I introduce those guests to you. Mr. Bob Hannes, who is the Programs Manager for the Metro District Probation Department. He has his BA degree from the University of Arkansas, his master's from Georgia State University, and is a candidate for the PhD degree in psychology counseling at Georgia State University. To his immediate left is the director of the Public Defender's Office, who is Mr. Vernon S. Pitts. Mr. Pitts received his BA degree from Hunter College in New York. He received his JD degree from Emory University as a member of the Georgia Bar Association. To Mr. Pitt's immediate left is Mr. Larry E. Carter, who is a probation officer for the Metro District Probation Department. Mr. Carter has his BA degree from Morehouse College and is a candidate for his master's degree in psychology from the University of South Florida. At this time, we'll join our panel in discussion as Mr. Bob Hannes addresses the historical background of the Probation Department in Fulton County. At this time, I want to first begin with Mr. Bob Hannes. Mr. Hannes, can you please give us a historical breakdown of the
In Fulton County, the Fulton County system was an independent probation system for many years. I believe the Fulton County system itself started in 1909. It remained, there was the statewide probation act, was enacted in 1956, and at that point it was a unification of all the probation departments, the independent departments in the various counties. However, counties could elect not to enter into that agreement, into the statewide unified act, and in fact Fulton County and Stone Mountain, or that area, did not enter into it, DeKalb County. They both retained their independent systems until a law was passed in the state legislature 3 years ago that mandated that those two counties do enter into the statewide system. At that point, in 1984, July 1st of 1984, both Fulton County and DeKalb County did become part of the statewide system and no longer part of the county system.
Okay. Does that also mean that there are still 10 districts here?
There are 10 districts in the state. The state is broken up into 10 districts that correspond with the 10 judicial districts in the state. Until Fulton and DeKalb came in, we did have eight districts, and then we expanded to 10 districts. I guess that was about a year ago or so. Okay.
And what was the main objective of the probation department?
I think the objective all along, historically, incarceration has been the form of punishment for criminals or for offenders. And in fact, after the Revolutionary War in 1776, all offenders were incarcerated in one form or another, either a county work camp, something like that. However, about 100 to 150 years later, I suppose, people could see that not all offenses required some type of incarceration, that in fact people could be supervised in the community. And that's really where probation started from, looking at less serious offenses where the person could be supervised in the community in which he or she lived, instead of being sent away to a county work camp or a state prison or even a federal prison.
Okay. Another question. Okay, in dealing with the probation department and its organizational breakdown, how is the structure of the probation department? I mean, you have a director because you're the director, and how do you have assistants under you?
Right. I'm not the director. My direct supervisor is the director of the probation, Metro District Probation. Then our organization, he is the director. Then we have 8 what we call unit managers and program managers, and I am one of the, I'm in charge of all programs in Metro District Probation. There are 7 other, within my area, we have intensive supervision program, we have a counseling program, volunteer resources coordinator, community service program, diagnostic program, a surveillance or urinalysis lab program that is all run as part of programs in Fulton County. There are then 4 case management units, and those are geographic. the officers in each one of those units supervise people according to where they live in Fulton County. There's a South Case Management Unit that's headquartered down in the South Fulton Annex, North Case Management Units in North Fulton Annex, and then the West Case Management Unit and Central, which are both presently located in the state courthouse area. We hope to be able to move those out into the community to get, actually we're trying to get officers closer to where the offenders are. We also have a couple other, there's a facilities unit that oversees the 4 diversion centers in Fulton County, the court services area, which provides officers in courts each day to actually work the courts, and the child support unit, which is part of court administration.
Mr. Vernon Pitts, what role do you perceive the defense attorney playing in between the probation department and your client?
Well, after you get out of law school and you've practiced for a while and gained some experience in the field of law, you realize that only Perry Mason gets all of his clients off, and only Perry Mason have all the innocent people. So there are a lot of cases in which your client actually committed the offense. The attorney's duty is to attempt to work out the best solution to the legal problems of the client. And we get a variety of cases, and under the law in Georgia, any case that does not carry a maximum penalty of death or life imprisonment can be probated. What we try to do in terms of our client is to work out the best type of sentencing agreement. And generally, if the person has not committed any other type of crime in the past, especially a serious crime, if the person is not likely to commit further crimes in the community, and if the ends of justice are met by placing that person back in the community with some supervision, then we will try and get that person placed in the community, paying off restitution if that is ordered by the court, or paying a fine if that is ordered by the court, but generally living up to the terms of the probation conditions that will be set by the court. It's at the discretion of the court whether or not to place a person on probation, and the court also imposes certain conditions. And our duty as attorneys is to try and get the best arrangement for the client, and hope that the client will live up to the terms and conditions of the probation, because after the person is placed on probation, then it's generally out of the hands of the attorney.
Before trial and during the trial, do you ever come in direct contact with the probation department?
Yes, we do. There are certain cases in which a pre-sentence investigation report is ordered by the judge. What we will do in that situation a lot of times is try and make sure that the probation officer has access to all the necessary information, so that the report will be one that shows the judge what type of person the individual defendant is, so that the judge can make a determination as to whether or not the person can go back into the community, not commit a crime, and therefore the community is safe with that person on probation.
It's interesting because with my working with the criminal justice system, the pre-trial report will always have just basically the information like the name, the social security number, the crimes they had committed, nothing else.
Some of them have a little bit more information, I think, about the person's lifestyle, employment history, and things of that nature. The judge needs that kind of information to make a valid decision on it, as to whether or not this person is going to be a threat to the community, or whether or not this person can be productive if left in the community.
Also, there is some psychological evaluation that is ordered by the court at some time in some cases. Have you ever ran into that type of situation in your own personal?
Yes. In some cases, because of the nature of the offense or the person's background, the judge will feel that there is a need for an evaluation. Sometimes the attorney, after interviewing the client, will feel that there is some problem, and think that it's necessary at that time to get an evaluation done. And generally the court, if the person is indigent and unable to pay for such an evaluation, the court will pay for it. And in a lot of cases it is necessary. We're finding in our office that there are a lot of people who are not, who do not have mental problems to the extent that they need to be hospitalized, but who do have some mental problems. And those type of people, the system is not set up to deal with those types of people. So what we try to do is work out some type of arrangement where after the psychiatric evaluation or psychological evaluation report, we will try and see that the person gets some type of counseling as a condition of probation.
Let me ask another question on that line. Some people are feeling that for certain crimes which are committed, that psychological evaluation should be a requirement.
Are you talking about like serious crimes involving victims, such as rape, that kind of... I think that we have the capability in Fulton County to do psychological evaluations. As I mentioned, as part of my responsibilities, I do oversee a diagnostic program. I have 2 people who are trained to do psychological evaluations. We can do psychological tests, interpretations, interviews, and actually write up a recommendation treatment plan that can go to the court. We're not doing a whole lot of those right now. We're not doing a whole lot of what we call the pre-sentence investigation, which is what you were referring to a few minutes ago. We do have that capability, though, and we do want to be able to expand that services to the court. I would agree. I think some crimes, and I'm not sure I would look just at the crime, though. I would look at the crime plus past history, I think, in trying to make a determination of which kinds of offenses specifically should require that.
Okay. Mr. Carter, on a normal circumstances, what would a judge look at considering probation?
Well, normally he would look at the type of crime that has been committed, the age of the offender. If a person is, say, in his late teens, early 20s, we would want to look at the type of crime and whether or not we feel that he would do well on probation. The judge would also consider the same kinds of things if it's an older person, and also looking at the nature of the crime, whether it's a minor crime as opposed to a crime such as rape or murder or like that kind of situation. Also look at whether or not the individual has committed a number of past crimes or past offenses, and that way he can make a decision as to whether or not this would be a good candidate for probation.
Take an example. If an individual, a child, a minor, has committed a crime, and he has committed several in the same category. For instance, like petty theft, and he was theft by taking, okay? And he comes up before the judge again. He has had probation and all these other instances. Would the judge, what would the judge do? Would he look at that case and say, well, I'm going to place him on probation again because this is a minor crime, or whether I'm just going to go ahead and incarcerate him for a period of time?
Okay, I think that what the judge would probably do would be to talk with the probation department or find out if there are alternative types of programs that we can get this person into. If it's a person that has committed more than one crime, it's the same kind of crime, and he is not in a situation right now where the judge may feel that continuous imprisonment, is the best thing for him, he may look at some of the alternatives that we have. One program that has gotten a lot of attention is the shock incarceration program. This is a program where that particular offender would be placed into a prison setting for approximately 90 days. While he's there, he is kept away from the other prisoners there or the other prison population, but he is in fact in prison. And that will give him a very good idea of what his situation or his condition is going to be if his behavior persists. In addition to that, some of the other alternative programs that we do have that the judge can recommend or place a person into would be one of our diversion centers where the person is watched very closely. He would be in a center basically 24 hours except for the time when he's at work. He would have to maintain employment while he's in the center, but the rest of his time is spent there. There's a staff of people who would work at the center to make sure that the person is living up to the expectations of the judge. Again, he would have to work. He would spend all of his time at the center. If things are going well for him, then he may be allowed to go home on the weekends to visit his family. But that would be very close scrutiny. One of the other programs that we do have that might be an alternative that the judge could use would be the intensive probation situation that we have at Fulton County, where a person, especially for drug cases and that kind of thing, would have to come in approximately once a week, maybe more. He would have to give urine analysis and that kind of thing, and he's watched very closely. Bob might be able to tell you a little bit more about the intensive team. That's one of the things that we're kind of I'm glad to see happening right now in Fulton County.
Mr. Hughes, you want to expound on that?
Yeah, I would like to, because it is it's a new concept that it was not originated in Georgia, yet Georgia, I think, has taken it further and implemented it in a much more structured way than any place else in the country. In fact, we have visitors coming in constantly from other states, even other countries. We had a man with corrections in Norway come in and talk to us several weeks ago about the intensive supervision program in Georgia. It is highly structured. It is intensive. The name says it all. It's not like, the one time a week is not quite it. That program requires 5 contacts per week with the probationer. 2 of those contacts are in the office. The other 3 are outside the office. It may be at the person's work site, where they're employed. It may be where they're doing community service, which is a required part of the program. Or it may be a curfew check. Everybody on the caseload, there's up to 25 people on a caseload. There are 2 officers, one a probation officer who primarily is responsible for the counseling aspects of probation, and then there's the surveillance officer. The surveillance officer is the one who goes around. He's usually working at night, and he's going by to check to see if they're home. If they've done 8 o'clock curfew, he'll be there around that time. He'll also come back at 10 o'clock so they don't slip out the back door, when he drives by. It's a very intensive program, very structured. They must work. They must pay fines, restitutions. They also are ordered to pay a supervision fee from $10 to $50, depending on their circumstances. And this fee, in fact, is what pays for the program. This program is not paid for through tax dollars. It's not paid for through the state of Georgia. It's paid through that probation fee that all probationers on intensive have to pay, and then other probationers also are sometimes ordered to pay a fee. So it's a program that we're very proud of, and it's highly successful. It's been in operation now for 3 years, and we're showing a lot of success in terms of people being successful on probation and being able to go off of intensive probation onto regular street probation.
There are about 9 classifications, a breakdown of your cases, and intensified supervision is one of them. So what I'm really interested in knowing, what type of cases would the court consider intensified that you really have to watch? Okay,
intensive is a special condition of probation. It is ordered by the judge from the bench. We do have different classifications, but the 4 classifications that we use mainly, maximum, high, minimum, and medium, come from a risk needs assessment. It's a form that was developed that looks at factors such as prior criminal history, age at first conviction, alcohol or drug involvement, drug abuse, marital family relationships, employment, education. All these factors have been weighted, and that score then yields one of those 4 levels of supervision. Intensive, however, is not one of those 4. Intensive is a special one. If an individual meets certain requirements, certain criteria, in Fulton County, we will then go back and look at the case. And the main criteria in Fulton County is if the offender has been committed, has been ordered to serve time in prison. Okay, he's been incarcerated at that point. We will then go back and do an investigation on him. This time it would be called a post-sentence investigation. And we would talk with the victim. If there was a victim in the crime, we would talk to all family members, the detectives working the case, the police officers, attorneys, anyone that knows anything about this individual. We would then write up a report that will go to the judge that would say, basically, we feel like we can take a chance with this individual. And instead of putting him in prison, let's try him on intensive probation. So at that point, it's an amended order by the court. Now, in some situations and in some other circuits where we do have intensive teams, it is done on a direct sentence. In other words, the judge from the bench will order that the person serve part of his sentence on intensive supervision. In Fulton, however, we do not do that, and we've shown that the people are more successful if it's amended order because they've been told by the judge, you're going to prison, and they're generally young people. We then come back and say, hey, we're going to give you another chance here. And so they're so relieved that they're pretty much going to do whatever you ask. And intensive is a very structured program, and it's hard to be successful on that. You're being watched constantly.
That's good. Mr. Carter, when the judge looks at a case and he denies probation, what are some of the things that he considers before he makes his choice to deny the probation?
Well, again, he will look at things like the kind of crime that has been committed. He would look at the history, like of the probationer or the person himself. Usually, for more violent crimes, murder, those kinds of situations, chances are the person would not get probation unless it's something like maybe vehicular homicide or that kind of thing. But if it was premeditated or anything like that, the judge wouldn't even consider it.
Okay.
That's what a lot of people don't understand about probation, I might add, is the fact that it's rarely imposed in very serious types of cases. As a matter of fact, there are some offenses that cannot be probated, say armed robbery. That, by law, cannot be probated, and it's a minimum sentence of 5 years, none of which can be probated. So there are serious offenses in which probation is not an alternative whatsoever.
So speaking in terms of restitution, you brought up, Mr. Hannes, what are some of the cases that the judge will look at and say, well, I require you, I judge that you bring forth and that you render to the said party who you injured restitution?
That's really been done for years. I think there's a lot more public interest in that right now. A majority of our cases now that do involve a victim involve restitution. What the judge will ask, well, actually, it's supposed to be done, as I understand it, prior to the sentencing aspect of the case. If there is a victim, the prosecuting attorney, their office is, as I understand again, in charge of determining what restitution there is, if any. If someone's been hurt, and it doesn't have to be a one-time set cost either. If someone has been injured and has ongoing medical bills, that can be ordered that the person will pay restitution, and there won't be a set amount. It will be, as the doctor bills come in, then the restitution is collected for it. Most judges now in Fulton County, if not all, will order restitution to be paid to victims if a victim undergoes a loss, either some kind of financial loss or physical kind of loss. And we are then required by law to collect that restitution from the individual. And in fact, we recently rewrote some of our policies as far as collections, and now, like usually you'll have an offender who's paying restitution and a fine. Instead of collecting the fine first, which simply goes into the state treasury or whatever, we collect the restitution first, because that's going to go to the victim. Once that restitution is all paid out, then we start collecting on that fine. So that's been a change in our policy, I think, in response to the public's demand, really, that victims be compensated for their losses.
Okay, the type of crime we know is important when probation is considered, and we have gone over those type of considerations. But what I want you to address is the issue of the individuals constantly committing the same crimes. We've dealt with it at the beginning, constantly committing the same types of crimes, and it seems like no change of heart. Like, they just continue to do it, and they have no distinguishing about whether I should continue to do it or whether I should cease. They continue to do the same crime. What I want to get at is, in those cases where the judge sees whether the individual has no change of heart, how would the judge then look at an individual person?
I would hope myself that after some time of that the judge would say, that's it, and you are going to jail. That may not happen. We have a real serious problem here, as I'm sure you're aware, with prison overcrowding. And it is getting more and more difficult to even find space to put somebody who has to be there, much less someone who we might can take a chance on. And I think what the judges in Fulton County do now is they'll increase the sanctions. Okay, they've been tried on straight probation and they failed. Okay, they committed the same crime again. The next step may be to put them in a diversion center where they do have that 24-hour surveillance. If that doesn't work, the next step may be, in fact, the special alternative incarceration, the 90-day incarceration period. So escalating in the amount of structure and in the degree of punishment is probably the better way to go. But I do hope that at some point the judge says, that's it. We're not fooling with this person anymore. He's going off to Reedsville or whatever.
Well, I've found also that is the case. The more an individual comes before the courts, especially committing the same types of crime, where the judge feels that he's given them a chance by placing them on probation, that each time the person comes before the court, then the punishment gets progressively stiffer. And I have found that to be the case. In addition to that, there are recidivist statutes in Georgia that are set up to punish people who have committed a certain number of crimes. So I think you could say that in the state, the punishments become more and more stiff as you commit more and more crimes.
Mr. Carter, when a person is on probation and he either fails to come to your office for a meeting or he leaves before he's supposed to leave, a warrant is issued for his arrest, correct?
Yes, if a person that is under my supervision fails to come in to see me, the section I work with is called Jones Supervision 73. Those people are required to report to us once per month. These are the people who are usually first-time offenders that the judge or the court feels that would probably do well on probation. If someone fails to come in and see me, or if they will not make a payment on a fine when they're supposed to, the first thing I'll do is to write them a letter to let them know that they do need to come and see me immediately, because we did not have that face-to-face contact, or he did not honor what the judge wanted him to do by making his payments on time. If the person does not report after I send him a letter, then my next step would be to issue a warrant, because I want to know what's happening with that person. I want some type of contact, either for him to come in and see me and let me know what's going on, or to have someone go out and pick him up and bring him in. At that point, after warrant has been issued, we do have an SOA team that we can give the warrant to, and they will go out and pick the individual up. But even on general supervision, it's very, very important that these people report when they're supposed to. So again, after I write them, if they miss one report, I'll write them a letter, and if there's no response, then I will issue a warrant.
There are many issues dealing with the probation department here in Georgia, and there are many questions I know the viewers at home have, but unfortunately we have ran out of time for this segment of the program, and we extend to you an open invitation to come back at a later date to further this topic, because there are certain issues that we really want to get into, such as probation of mentally insane persons that is becoming very popular now in this country. And at this time I want to thank you on behalf of Georgia Association of Black Women Attorneys, and we want to continue this discussion now by asking a few general questions, just your basic opinion about what the overall perspective of the future for the Department of Probation here in Georgia. Mr. Hannes?
I think what you can see in the future very clearly is there will be increased supervision by probation officers in Fulton County. We are getting more officers allocated to the state legislature each, when they have their sessions, and they're the ones who determine how many new officers we get. They've been extremely cooperative with us, and as we increase supervision, though, you're also likely to see more people going back to prison for failure to abide by the conditions of probation. I think that's one thing that the public is demanding, and I certainly agree. If they're supposed to do something, then they either do it, or then they pay the consequences for it.
Mr. Pitt?
I think probation is a very viable alternative to sending people to jail. As a matter of fact, I think there are 100,000 people on probation in the state at this time. The jail capacity in the state is only for 16,000 people. So numerically speaking, probation is an alternative that has to be at least considered by the judges in reaching their decisions in sentencing defendants.
Okay, we thank you for joining the Georgia Association of Black Women Attorneys program this evening, Legally Speaking. I'm your host, Kathy Carter. If you have any questions, you can address them in care of this studio, and we thank you. We appreciate your interest in this community affair.
Welcome to this episode of the Georgia Association of Black Women Attorneys Community Service Program, Legally Speaking. Tonight's topic is the death penalty, in particular its impact on the black community. My guest tonight is Brian Stevenson. Brian is a graduate of Harvard Law School and is a lawyer with the Southern Prisoners Defense Committee. The Southern Prisoners Defense Committee is a non-profit organization that provides legal representation for death row inmates in 9 states across the South and is located here in Atlanta. It is also involved in challenging prison conditions in several southern states. Good evening, Brian.
Good evening.
I would like to begin by pointing out some basic facts about the death penalty. Since 1930, when statistics were first kept, over 3,891 executions have been conducted here in the United States. As of December of last year, over 1,405 prisoners were under sentence of death here throughout the United States. All of these prisoners were convicted of murder, and of these 1,405 inmates, 1,388 were male, 17 were female, 804 were white, 41.5% were black, and 16 or so were of other races. 63% of these inmates were in southern states, and there were 111 inmates on death row here in Georgia. Throughout the year of 1984, 21 executions occurred in the United States. Georgia is one of 37 states with the death penalty. 2 states do not have the death penalty. Those are New York and Massachusetts. In Georgia, it's particularly important to note that there's no minimum age for the imposition of the death penalty. Okay. Brian, I guess my first question is, what are the capital offenses here in Georgia? That is to say, what crimes could result in the imposition of the death penalty here in Georgia?
Well, the definition of what is a capital offense in Georgia is really a function of the history of the death penalty within the last 20 or 30 years. In 1972, the United States Supreme Court, in a decision called Furman v. Georgia, basically outlawed the death penalty or administration of the death penalty because it was being applied in a very arbitrary and freakish manner. There were no specific statutory guidelines to inform a jury or to inform a prosecutor about which cases were eligible for the death penalty and which cases were not. So in 1972, the Supreme Court basically said that states have got to come up with more specific guidelines to determine what is a capital case, what is a case that is eligible for the death penalty, and what is not. A lot of people in 1972 thought the Supreme Court's decision was basically the end of capital punishment in America. However, not long after the Supreme Court's decision in 72, many states, Georgia was a leader of one of these states, immediately reenacted new statutes, new capital statutes, that sought to define what was a capital offense with a lot more specificity. In Georgia, the statute they created basically defined a capital crime as any intentional killing that is accompanied with about 10 aggravating circumstances. And the circumstances range from things like the commission of a crime or murder, accompanied with some other felony, some other rape, kidnapping, aggravated assault, etc. Killing a police officer, killing someone for money or murder for hire, killing someone in what is deemed a wanton, cruel, or torturous kind of way. There are about 10 circumstances that sort of define what are capital statutes. However, the definition of what is a capital crime, the definitions are broad enough that it's really hard to say what isn't a capital case. I mean, if there's a case where there's been a murder, I think the prevailing attitude is that there are ways that prosecutors can use one of the circumstances to get a death sentence. For example, there's an aggravating circumstance that's frequently used in capital cases here in Georgia that basically says if the crime was committed in a harmful or a torturous or a particularly vile manner, then that's eligible for the death penalty. To a lot of people, any crime, any killing, any murder is harmful and vile and torturous, and therefore it's eligible. So while there are specific aggravating circumstances that determine and guide what is eligible for the death, which cases are eligible for the death penalty, the parameters are fairly broad.
Okay, you mentioned the prosecutor. What role does the prosecutor play in determining when a particular offender might or may or may not be imposed with the death penalty?
Under Georgia's new guidelines related to the prosecution of capital cases, prosecutors have a great amount of discretion and latitude in deciding which cases they will prosecute as capital cases and which cases they will not. Under the Georgia statute and under the Supreme Court's rulings, cases that are eligible to be prosecuted as a capital case do not have to be prosecuted as capital cases.
Okay.
As a result, the prosecutors pick out the cases they think are most important, usually cases where there's the greatest amount of interest, etc., in determining which cases will be prosecuted as capital cases.
So in the real world, the prosecutor uses his own human instincts and decides when and when not he's going to ask for the death penalty.
Absolutely. I mean, initiating the death penalty is almost exclusively the function of the prosecutor. He has almost uninhibited discretion in determining which cases will be prosecuted as capital cases. Apart from those statutory guidelines, the decision is his.
Okay, well that raises a question of the quote-unquote myth that the fact that the death penalty is applied equally. I mean, a lot of people will tell you that, or they believe that the death penalty is applied equally to every offender which may have caused a murder, and regardless of race, color, creed, economic background. Is that true?
Well, I mean, there's been a lot of discussion and study and work put into the issue of how the death penalty is administered and applied in the state of Georgia and other states as well. I think it's sort of beyond dispute that race plays a significant, if not the dominant, a dominant role in determining which cases are prosecuted and which cases are not. The history of the death penalty in America, and specifically in Georgia, is one that bears out the prominence of race.
Okay.
I mean, during the 18th century and the 19th century, states like Georgia had specific codes, specific laws that were applicable only to black people, only to persons of color. During the 19th century, it was a capital offense. You got the death penalty if you were black, and you committed a rape, you attempted a rape, you committed a killing. In some instances, you committed an aggravated assault, or even if you were accused of committing these kinds of crimes, you were eligible for the death penalty, and more often than not, you got it. Those statutes were race-specific. In the statute, it says it is a capital offense for a black person to attempt rape of a white woman. There were countervailing statutes that applied to the general population that were not capital offenses. It was not a capital offense. It was not something that you could get the death penalty for if you were white and you attempted rape of a white woman, or you attempted, or it was attempted murder of a white person, etc. So you have this history of explicit race codification on who is eligible for the death penalty and who is not. In the early 20th century, there were courts in Georgia, appellate courts, trial courts, that were basically taking judicial notice of the fact that the races, that black persons were inferior, that there was a double standard that was applied to to criminal cases. A black person committing a crime against a white person was, in the opinion of the judges of this state, a more serious offense and therefore subject to more serious punishment. That's the history of the death penalty in Georgia and across the state, and that's what's printed. Of course, now the laws applying the death penalty, the laws that define the death penalty, are race neutral. I mean, Georgia's statute now does not make any references to race or particular penalties for some persons.
On the face of the statute.
Oh, that's right, on the face of itself. However, I mean, the application, the tradition of administering criminal offenses or criminal charges against black persons accused of committing crimes against white persons differently than administration of those charges against white persons accused of committing offenses against other white persons has continued. And there was a study done by the NAACP Legal Defense Fund. Began in 1980. It analyzed every homicide between 1973 and 1980 in the state of Georgia. There were about 2,100 murders considered, about 2,500 actually. And what this study revealed was basically the very clear, distinct disparity that race created in the administration of these cases. Of the 2,100 cases, about 1,400 of them were black victim cases. About 700 were white victim cases. However, the amount of people or the number of cases that resulted in capital sentences were over 95% white. That is, the overwhelming majority of those cases that ended up in capital sentences, death penalty sentences, were those smaller subset of white victim cases. The other thing that this study revealed was that prosecutors used their discretion in ways that really did create an inference of race discrimination. Black victim cases were pled out much more frequently. About 50% of those 1,400 cases resulted in plea bargains, where the defendant would get some very minimal sentence or some lesser sentence. A greater number of those black victim cases were actually tried. That is, they would just sort of get a deal or get some kind of plea to a lesser offense and never sort of try the person. And an even smaller percentage of those cases were ever proposed as capital cases. So the net result was is that 95 or 96% of the persons on death row in Georgia are there because their victims are white. That history, that administration, that application of the death penalty is not unique to Georgia. It's something that I think is a factor and a function of the history of criminal justice in the South, but it's also very prevalent in other southern states. It's not something that's just confined to the death penalty either. I mean, there are a lot of studies that point out the prosecution and the role of race in the prosecution of less serious criminal cases as well.
So it appears, based on the fact we discussed earlier, that is that over 41% of people on death row are black, and we only comprise at most 15%, 12 to 15% of the population. So would you agree then it appears that regardless of what side of the fence we stand on, whether we are in favor of the death penalty or we're against the death penalty, we still, particularly the black community, needs to address the unequal application of the death penalty?
I think absolutely, and I think the statistics on the race of the defendant are relevant because what the studies have shown is that black defendants accused of killing white victims get much harsher treatment than white defendants accused of white victims. But I think what is particularly relevant to the black community is how nobody gets harsh treatment or particularly rigorous application of the law if they're accused of killing black victims. And it seems to me that's sort of the essence of the improper administration of a lot of criminal laws, but certainly the death penalty. And it does point out the need to sort of really think hard about our attitudes about the death penalty, our attitudes about the criminal justice system. I think a lot of people, when they think about their position on the death penalty, they respond sort of at a gut level. They think about whether it's right for another person or for human beings to sort of exercise judgment over other human beings. And I think that's a very important and relevant consideration to make. However, it seems to me, even if you decide that the death penalty is moral, that it's proper for people who are basically in support of the death penalty to judge other people and determine whether they're going to live or die, if you decide that that's proper and moral, you still have to decide whether it can be administered in a way that's fair and that's just. And that the decision that the death penalty is right in some moral sense is not the only thing that you have to decide. You've also, it seems to me, got to decide whether it's going to be applied in a way that's fair, in a way that's racially neutral, in a way that doesn't devalue the lives of black people, in a way that doesn't oppress people because of their race or their wealth or their status or other improper considerations.
If you were to draw a picture for us of the average inmate on death row, what would that person be like?
I think it's fair to say that everyone on death row is poor. Most of the people on death row have had infinitely inferior educations. They, by and large, do not have half the resources that most people have early on in their lives. That is, a great number of the people on death row in southern states particularly are the victims of family abuse, child abuse, have been subjected to a lot of indignities as children, have lived in environments where crime is basically a way of life. They've been, more often than not, introduced to the way of crime through parents, through siblings, through other people that they're very close to. We have clients who were basically taught how to steal by their fathers, encouraged to steal by their parents. And I think it's fair to see that these are people that have been socialized into a life of crime. It's not true of everyone. There are clearly people on death row who have never committed crimes before, whose the process they went through of getting on death row is unique and very different. But I do think it's fair to say that there's a great number of people on death row who are poor, uneducated, and have been subjected to environments that facilitate and some would argue foster serious criminal activity.
The socioeconomic background of the inmates and their educational background. If I'm an attorney representing someone who is has committed a capital offense, do those factors play any part in my defense of that offender? Absolutely, and this is one of the things that a lot of attorneys that represent people on death row at the trial level are not aware of, or they don't take advantage of. But under the Supreme Court's rulings and under the statutes of Georgia and other southern states, attorneys are permitted to put on all mitigating evidence that is available. That is, anything about this person, the person that's been accused of the crime, that is relevant to why they committed the crime, that is relevant to why they should not be executed, they should not be killed, that is relevant to how they got to where they are, can be put before the jury. And in really sort of determining whether someone is going to get a life sentence or a death sentence, the importance of this mitigating evidence just can't be understated. But yes, as an attorney, you would want to find out everything about this person that you could possibly find out, and not feel in any way embarrassed or reluctant to gather that information and put it before the court. You are arguing for that person's life. And the fact that this young man was abused by his father, was abused by his mother, grew up in a barn, or was subject to all kinds of physical and sexual and other kinds of abuse as a young child, that these things influence his attitudes about other people, they influence his thought process about the value of life, etc. All those things are relevant, and for trial attorneys that handle these kinds of cases, it's very important for them to put all that evidence before the jury. Now, earlier you mentioned that over 90% of the inmates on death row are poor. What impact does that have on the type of counsel they've received, and the fact that they're there? Yeah. Because they're poor. Yeah, I think it's most of the people that are on death row had court-appointed counsel, and many people believe, and I certainly do, that a lot of these people are denied effective assistance of counsel at the trial level, and that's basically how they get where they are. It's not to say that the trial attorneys that handle capital cases are bad attorneys, but if you don't have any resources coming from the client to help you investigate, hire witnesses, hire experts, do the kinds of things that you might be able to do if the client had money to put on the best defense possible, then you're not going to put on the best defense. I think it's fair to say that the people that are on death row, in to a great extent, are there because they don't have those resources to put on the best defense. And a lot of people on death row have cases where there are serious issues about innocence, there are serious issues about their competency, their insanity, their culpability in committing the crime. A lot of that stuff can't be brought out because their counsel, their trial counsel, doesn't have the resources available to really sort of investigate and pursue and gather the information necessary to make that defense. Okay, now I understand that the Southern Prisoner Defense Committee, who you work for, primarily does appellate work. That is to say, after someone has been convicted of a capital offense and given the death penalty, you take care of appealing that sentence. That's right. What impact does the nature of their counsel, the kind of counsel they have on the appellate process? Well, it has a tremendous impact, actually. The way the courts have begun dealing with capital cases, I think it's fair to say that there's a feeling of hostility toward people on death row, and the fact that they get death sentences and are not executed within 30 days. And what the courts have begun to do in responding to, I think, the public pressure to get more executions, to have them happen more rapidly, is to hold lawyers handling these cases, and consequently the people themselves, the offenders themselves, to very high standards of procedural and technical
preservation of issues. That is, if a trial attorney doesn't object to everything that goes on in the trial that is bad or that is unconstitutional or that is unfair, notwithstanding the fact that it's a fundamental violation of that person's right, that it's unconscionable, that this outrageous thing has happened, the courts are not going to grant relief or give that person another hearing or reanalyze that person's case at all, just because that lower court counsel did not preserve the issue. So for people doing appellate work, you basically have to sort of take whatever is in the record and try to get the courts to recognize it as a constitutional violation. It creates other problems, just sort of the demographics of people on death row. There are expenses in appellate litigation. There is no right to counsel in Georgia beyond the trial level. That is, everyone accused of a serious crime has a right to an attorney. However, that right to an attorney does not extend past that trial and one appeal to the state Supreme Court. Most of the people on death row that have gotten relief have got recognition of the fact that there was something about their trial that was unconstitutional, that was unconscionable, have gotten relief from the federal courts. There is no right to counsel at that level. So the people on death row are basically dependent upon some attorney volunteering to take their case, to look at their record, and then to present their issues to some collateral state court or to a federal court. And it does create problems.
Okay, how many attorneys, particularly black attorneys, are out there doing that, willing to take on a case regarding a person on death row, take on the expenses of that case? I assume that that attorney is going to have to bear the filing fee expenses and the expenses of getting witnesses and experts. How many attorneys are out there willing to do that?
Well, unfortunately, there are over 100 people, over 120 people on death row in Georgia. There are not 120 attorneys willing and ready to take their cases. A lot of people on death row do not have counsel. The situation in Georgia is as bad as the situation in other states, Florida, Mississippi, Louisiana. There are persons on death row that do not have counsel and really have no process or mechanism for getting counsel. Organizations like ours really try to recruit attorneys to do this work and also provide emergency representation when an execution date has been set and there's been no review of a person's case. But it's become increasingly difficult to get attorneys involved in these kinds of cases. There's a lot of hostility toward representation of these people. There's a lot of political and public, I think, antipathy towards the handling of these cases. There are a lot of very sort of significant costs in trying to do the adequate investigation and just analysis and research that's necessary in conducting these cases. And as a result, it's just very difficult.
Now, you talked about hostility toward attorneys who argue death penalty cases. What is the impetus of this hostility? Where is it?
Well, I think it's just really, I mean, just an indirect reflection of the hostility toward persons who are committed, accused of capital crimes. And in some ways, that's not to be unexpected. I mean, most of the people that are on death row in Georgia have been accused or committed crimes in very small and rural communities. It's a big event when these crimes are committed. The community is outraged. There's a strong feeling that that person should be executed, and that person should be executed with all deliberate speed. And a lot of these communities, the attorney is viewed as some obstacle to their execution, to that community expressing or implementing its desires. So there's that kind of pressure, I think. I mean, it's clear that in Georgia, the overwhelming majority of the people in the state favor the death penalty, and some are quite enthusiastic about its application.
Okay, this so-called enthusiasm in many, particularly rural communities, about the death penalty and the publicity that is given cases that usually result in the death penalty, particularly in rural areas. What impact does that have on the selection of the jurors?
Well, I think it's really quite relevant. I mean, under the Supreme Court's rulings in 1968 and under the statutes that guide the application and the prosecution of capital cases, persons who are conscientiously opposed to the death penalty cannot sit on juries that hear capital cases. That is, if you're opposed to the death penalty, you cannot be on the jury that decides whether the person accused of the crime is going to live or die. The people that sit on those juries have to be, in some way or the other, supporters of the death penalty. So first of all those people that might sort of take some dim view of this sort of reactionary hostility toward some person committing a crime are in some ways initially excluded.
Okay.
What's left in the jury are those persons that have some support for the death penalty. Because they're in these small counties that you mentioned, they then have to deal with their obligations, their responsibilities to give the appropriate sentence. Now, obviously, not every jury, not every juror is under that same kind of pressure, but there are clearly cases involving inmates now on death row in Georgia and in other states where the trial was conducted in an atmosphere of real hostility. There was a lot of pretrial publicity about the crime and about the expectation that this person get a death sentence.
Okay.
And I don't think it's there's any secret about the fact that those jurors sitting on that case had some sense of that, had some notion that, yes, there was strong community sentiment that they give a death sentence, notwithstanding the merits of the case.
Now, you said there was a Supreme Court ruling that said that someone who's conscientiously opposed to the death penalty cannot sit on a jury. Now, is there a corollary? That is to say, that someone who, beyond a shadow of doubt, feels that everyone should be given a death sentence, regardless of what crime they commit, eye for eye, a tooth for a tooth. Is there, I mean, if I'm a defense attorney and we're sitting there picking the jurors, that is during voir dire, can I sit there and, as a defense attorney, find jurors that are conscientiously, or avoid getting those people who are conscientiously in favor of the death penalty?
Right. Absolutely not.
Okay.
And unfortunately, cases of people on death row in Georgia and other states are replete with sort of just transcripts of the voir dire or the interrogation of jurors that bear this fact out. There are lots of people that sit on juries that indicate their strong support of the death penalty, their strong, their enthusiasm for seeing executions, etc., that are not struck and can't be struck under any sort of legal or Supreme Court decision.
What would you tell members of the black community who want to be involved in actions against the death penalty? What can they do?
Well, there are a number of organizations in the Atlanta area that are involved in this activity. I think they can contact those organizations, the Georgia Coalition Against the Death Penalty, our organization, and there are a lot of things to do. Just call us and we'll talk about it.
Okay, thank you very much. Please stay tuned for the next airing of Legally Speaking. That was a quick half hour.
Good evening, and welcome to Legally Speaking, brought to you by the Georgia Association of Black Women Attorneys. My name is Julie M.T. Walker, and I will be your moderator for this evening's program entitled Tax Tips About the Internal Revenue Service. I am a tax attorney with the Internal Revenue Service, and I have been one with them for the past 5 years. I have an advanced degree, a Master's of Law in Taxation from Emory University. Because of my position at the Internal Revenue Service, I am restricted with my participation on this program tonight. However, I am pleased to bring you two other panelists who have excellent backgrounds. They are Tony Grant, who is a former IRS agent who worked in the Examination Division of the Internal Revenue Service for 5 years. Presently, he owns an accounting and tax consulting firm and can be reached at 425-0069. We also have Cheryl L. Alford, who is a certified public accountant and an attorney in private practice in downtown Atlanta. Ms. Alford specializes in taxation, real estate, business law, and wills, and she can be reached at 524-1777. Have you ever been examined or audited by the IRS and thought that it was the most frightening experience? Well, tonight's program should relieve you of some of your fears and clear up a lot of common misconceptions. First, Tony Grant will explain the organizational structure of the Internal Revenue Service. They are 4 divisions: the Examination Division, Collection Division, Appeals Division, and the Criminal Investigation Division. Tony?
Thank you, Julie. The Examination Division is the first division that most taxpayers face upon receiving notice of an audit with the IRS. The Examination Division would conduct the audit, and they will set up a tax liability. And the Collection Division, their responsibility lies in collecting the taxes due after the taxpayer has been through the entire process. In a nutshell, the Criminal Investigative Division, they only get involved in cases after a taxpayer has been through examination and the taxpayer has been determined to be fraudulent on the tax return. Then the Criminal Investigative Division will get involved. We also have the Appellate Division, which gives the taxpayer a chance to be heard by someone other than the examining agent. At this level, the taxpayer normally gets a chance to present his side to the IRS, and in most situations, the settlement is reached at the appellate level before going on to the courts.
Thank you, Tony. What is the first thing that someone should do if they receive a letter or a phone call from the Internal Revenue Service?
The first thing one should do is to look for the records to substantiate the item's claim on the tax return. That's the first step that one should take.
Okay. What records do you need for the audit?
The records that are necessary generally will be your canceled checks to support any deductions taken on the tax return, any receipts that you may have had or invoices, bank statements or used, similar type records. Third-party statement could also be used, assuming that the third-party individual is not a family member.
Okay. And how long should one keep their records?
Records should be maintained for 3 years from the date the return is filed or due. I recommend to most taxpayers to keep their records for 6 years. This will enable a taxpayer to meet the record-keeping requirement for the IRS, which is 3 years, and the additional 3 years will be to help themselves. As an example, if a taxpayer were to file a claim for some excess investment credit that they may have had, and they could not use it on their 84 return, they will take it back 3 years to 81. And if on the 81 return it is determined that there is more credit left that could be used, or there was some credit on the 81 return that could be taken back, you can go back an additional 3 years to 1979. So I recommend to most taxpayers that 6 years should be sufficient, even though the law only requires 3 years.
Okay, with respect to the 3 years, are you saying 3 years from April 15th only, or?
Right, Julie. 3 years from April 15th, or 3 years from if the return had an extension, it would be August 15th.
Okay. Now, does the taxpayer have a choice of where the audit will be conducted?
Most taxpayers have a choice of where the examination will be conducted.
Oh.
That's true.
Okay. Is it better for the taxpayer to allow the IRS agent into their home, or to request that they go to the IRS office?
I will recommend to most of my taxpayers to conduct the examination, if at all possible, at the IRS's own office, or preferably at their representative's office, because this will keep the IRS from snooping around their homes and their businesses. So those will be the preferable locations.
And just as another aside, how should a taxpayer dress when they go into the IRS office? That is an important...
That is very important.
Tip.
And I will recommend also that they dress conservative. Keep the diamond rings and the expensive jewelry at home. Do not try to impress an IRS agent with your wealth. They look to these items and they try to compare your wealth to your tax return, which at the time the return was filed 2 or 3 years back, the taxpayer may not have had a substantial amount of funds to purchase the expensive items. So to avoid answering questions, I will just dress conservative and leave all expensive jewelry and items at home.
Okay, what information should one provide to the IRS?
The IRS normally will send a letter out to taxpayers asking for specific items that they would like to look at during the examination. I will provide the IRS a copy of all items that they request. Do not try to provide additional information, because if you do, the IRS could use the information even though they didn't ask for that information against you.
Okay, can you give us an example of what you're talking about when you say give only the items that are requested?
I have a good example that comes to mind, Julie, and that is, assuming the IRS agent were to ask the taxpayer, how much does your Sea Island condo cost? The correct answer to that will be $200,000. The incorrect answer will be $200,000 from an inheritance received from the death of a family member. And the reason that that answer will be incorrect, it prompts the IRS agent to look into whether or not that family member had filed an estate tax return upon the death, whether or not their heirs had filed an estate tax return. So be truthful, be specific, and only answer the questions as they're asked without volunteering additional information.
Okay, Tony. Suppose that while you are preparing for the audit, gathering your records, you realize that you have forgotten some expenses or deductions that you're legally entitled to, and now you're about to go into the IRS office. What can you do about those items that you forgot to claim?
Most taxpayers, including myself, often forget items in a rush to file their return on April 15th. I will gather the documents for all the expenses that may have not been on the original return that I've filed, and I will present these to the examiner upon the examiner asking for these items. If the examiner does not ask for these items, I will wait for some time at the end of the examination after the examiner has presented his or her findings, and at this time I will ask the examiner, could you consider the additional items here that were not claimed on my return? And I think the process in doing this is better to do it at the end, Julie. And the reason for that is the taxpayer will avoid antagonizing the IRS agent early on in the examination with all these items that he forgot on his return, and it creates a more workable atmosphere with the IRS agent.
Okay. Cheryl, is the examiner's report the final word?
No, Julie. The taxpayer does have recourse. The first step he could take would be to appeal to the examiner's supervisor. If he still did not agree with the supervisor's findings, he could appeal to the IRS. That would require an appeals conference. And if the deficiency is at least $2,500, you have to have a written request a written protest to accompany the request for an appeals conference. If the taxpayer still does not agree with the findings, he can appeal to the tax court. There's one thing a taxpayer should remember, though. You get your case heard in tax court if the taxes have not been assessed or paid. So you need to file your petition quickly to be sure that you don't get assessed before you get your petition filed in court. The case is heard by a tax court judge. There's no jury. The tax court judges are very sophisticated. They know tax law very well. The other alternative for a taxpayer is to go ahead and pay the taxes and file in district court for a refund. In district court, there is a jury of his peers, and the judges are not experts in taxation, and I think the taxpayer probably has a better chance in district court. So those are the options available for the taxpayer.
But to clear it up, you have to pay ahead of time what the IRS says that you owe.
Yes, if you want to go to district court and file for your refund.
Okay.
There's one more alternative, and that's the small case procedure with the tax court, and that is if the deficiency is less than or equal to $10,000. So that's much simpler for the taxpayer, and that's another procedure that's available to him.
Okay, Cheryl. Tony, if it is determined that you owe additional tax, what is the procedure for collecting that tax or for paying it?
You will receive a notice from the collection division normally, and you'll receive that notice approximately 60 days after the tax has been, the findings from the examiners have been received.
Okay, and approximately how long does it take for you to get a bill from the IRS telling you that you owe X amount of dollars?
The time period in which you receive the bill and you have to make the payment is approximately anywhere from 5 to 6 months, I would say. And the process goes because first it takes 60 days before you receive your first bill. After that 60 days, that bill will have a 30-day notice in which you have to pay the taxes. That's 3 months. If you don't pay the taxes after the 3 months, you have an additional second and third follow-up from collection you will receive before the IRS starts to take drastic actions. So I would say you have 5 months in which to pay this tax liability.
Can you automatically pay in installments, or what is the procedure?
IRS, unfortunately, no longer allows taxpayers to pay on installment. The taxes are due upon assessment by the IRS unless you can prove that your situation is pretty bad, you don't have any assets in which to liquidate, that you could pay your taxes, and your credit is ruined and the banks would not loan you any funds. In such situations, the IRS will allow 6 months in which to pay the taxes.
Okay, and they would require you to fill out a financial statement. Is that correct?
Exactly. You'd have to fill out a financial statement and to pay the taxes. Let me point out one more thing, Julie. At the 5-month period that I'm discussing, the interest and penalty are accumulating during this period. The penalties run from anywhere from 0.5% per month up to 25% for failure to pay taxes. There could be a penalty for negligence on the tax return. That's a 5% penalty that will bring the penalties to 30%. And in addition, you could have interest of 12%. So you could have 40%. Sometimes the interest and the penalty is equivalent to the taxes owed.
So therefore you request, or it is recommended, that people pay right away.
I recommend to most taxpayers to pay as soon as you receive the first assessment.
Okay. The penalties and interest, is it ever possible to get those waived at any point?
The penalties and interest can be waived only during the appeals process, but after the tax has been assessed, there is no waiver of penalties and interest. It stays on the records if it's not paid.
Okay. Cheryl, what if you have a taxpayer who has never filed a return, or one who has started filing a return and then just for whatever reason, procrastination, I got too busy, they stopped filing? What would be your advice to that person?
Well, Julie, I have a lot of clients that come in my office with that very problem. Either they, for some reason, didn't file, they got busy that year, whatever, and then they feel that, well, I didn't file this year, but now I'm afraid to file for the next year. But they think, well, I'm okay because they owed me money. That's a misconception, and I think taxpayers should know that by federal law, you are required to file a tax return every year, whether you owe the service money or they owe you money. So I impress that upon my clients that it's important that they file and develop a filing history as soon as possible. Some people think that, well, if I don't file, they don't know about me, or for some reason that they'll just go away, but that's not true, because W-2 forms, 1099s, interest income from savings accounts, and starting in 1985, the interest paid on mortgages by individuals and mortgage companies is reported to the service. So they know you've got some income and they expect some returns from you.
Okay, Cheryl. In a small business operation, can you tell us who would be responsible for filing the employment tax returns? That seems to be a common problem.
Yes, it is, Julie. I've had several clients recently who've come in with that problem. If you have the authority to sign on, has a signatory on the bank account, you could be responsible for payroll withholding taxes. I've had a client who was not an officer. He did not have any ownership in the company, but he did have the right to sign, has one of the signatories on the account, and he was assessed the tax for withholding taxes that were not paid.
Okay, Cheryl. Many people fear that the IRS will take all of their possessions once they owe the IRS, including their house and their bank accounts. Can you explain the difference between a federal tax lien and a levy?
Yes, Julie. A federal tax lien is an assessment by the IRS against a taxpayer's property, all his property, wherever situated. They record that. It's a matter of public record. And to have that taken off your record, you have to first satisfy the tax and then get a formal release from the IRS and then go back to the courthouse and file the release. I've had several clients who could not sell a piece of property because there was a federal tax lien on it, and they had to pay that lien before they could sell their property. Levy, on the other hand, is a lien against the taxpayer's wages or salary, and this is what the IRS usually tries to do first, is to enforce the levy. If they find that the taxpayer is trying to sell off property or somehow leave the jurisdiction, then they will assess a lien against all of their property just to protect their interest.
Okay, and will the levy be applied against a bank account as well as wages?
Yes, it will be applied against a bank account. And the levy, again, if it's satisfied, then the IRS will take it off your record, and you will have no more problems with that.
Okay. Tony, can you go to jail for the non-payment of taxes, or can you further explain the criminal investigation division?
Yes, Julie, you can go to jail, but only if the tax return was fraudulent or if you did not file a tax return. And by fraudulent, I mean omission of substantial income on the tax return, or overstatement, gross overstatement of your expenses for which you knew that there were not any records, or you did not incur or pay these expenses.
Okay, Tony, you mentioned the word fraud. Can you tell us what constitutes fraud, which would lead to a possible jail sentence and a fine?
Generally, fraud runs from anywhere from someone not filing a return, as I mentioned to you before, to someone just not putting the right amount of income, assuming that you made $100,000 and on your tax return you only show $50,000. That's fraud on its face.
Okay, what about deductions on the return? The itemized deductions, what would constitute fraud on Schedule A?
Fraud on Schedule A will be claiming contributions, excessive contributions that were not made to the churches, deducting medical or interest expenses that were not incurred. All those items constitute a fraudulent filing of a tax return.
Okay, can you explain what tax evasion would be? That is the most serious criminal offense. And could you just illustrate what evasion would constitute?
Tax evasion is knowing that you have earned a certain amount of income and failure to report this amount of income to the IRS, knowing that you had a responsibility to do so. So it's clear, a lot of taxpayers, it's clear that if you earn the income, I think most taxpayers should be aware that this income will be reported to the IRS if you're an employee through W-2s. And if it's not through W-2s, the IRS can go to third-party sales and have them produce the checks and that were paid to you for income received during that year. There's a misconception that if you receive cash, you don't have to report the cash. The IRS can trace cash, and I think it's important for taxpayers to note that dealing in cash, you have to spend that cash, and in most cases the IRS looked to where the cash was spent, and then they said if you had the money to spend on these items, well then you have the money to show in your income. And that's one way the IRS comes about determining the cash income that an individual may have. Okay.
Cheryl, briefly, could you speak about some tax-saving tips that people could use, such as the IRA, the interest deduction, charitable contributions, and medical mileage?
Okay. Well, the IRA is a deduction from your tax. It's $2,000 up to a maximum of $2,000 for an individual and $4,000 for a married couple filing jointly. I think what people need to know is that you don't have to contribute $2,000 to an IRA in any given year to get the deduction. You can contribute as much as $100 to an IRA and you still get $100 off your taxes. The contributions, a lot of people say, well, I didn't give anything to the church this year, so I didn't give any money to the church this year, so I don't have any deduction. But a lot of people give their service to the church, and while their service in and of itself is not a deduction, they can deduct any expenses that are related to that service. Say, for example, they use their car to deliver some clothing to some families in the neighborhood in the name of the church. They can deduct their mileage. And in 1985, that mileage would be 12 cents per mile. Or They can take their itemized deductions. What if they spent gas on their car? What if they had to have some secretarial services or some copying? All that is deductible if, in fact, it was incurred on behalf of the church.
Okay. A couple of more tax tips. Tony, can you explain income averaging and business mileage?
Sure. Income averaging is an excellent source of tax planning. It's probably the most overlooked deduction that exists today. Anyone can income average if they earn substantially more income in the present year, or if they won a prize or a lottery, or assuming there's a large bonus given from their company. All those individuals are candidates for income averaging. People that recently graduated from college and started earning a large substantial salary, that's a good candidate for income averaging. And the way you income average is you take the last 3 years income and take the average of the last 3 years, and if your current year income is 120% of your last 3 years average, then you could qualify for income averaging.
Okay, and finally, tell us about business mileage.
The business mileage is I consider the second most overlooked deduction. Most of us have 2 or 3 jobs, and traveling between jobs, we can deduct the mileage that we incur between jobs, or the mileage we have for seeing 2 or 3 clients during the day. These are legitimate deductions that are taken on Form 2106 at 20.5 cents per mile.
Okay, Tony. Well, I'd like to thank both of our participants. The IRS is a huge organization. There are many deductions.